to get the job, you will most probably want to know who you're going to work with or what the institution. You'd want more information, maybe to be up to speed about what happened since you left, as in her case. So for me, that would be natural. That would make sense. I would also do that. And so I did not in any way insinuate that she's a spy by so doing.
I apologized to you a long time ago about using the word spy. I'm using SSA now. I'm saying you are saying that you would, in other words, now what you want us to believe, or want the committee to believe rather, is that Advocate Mkhwebane, when she was applying to become the public protector, went to the SSA and gathered information about people who are working there. And one of the SSA agents told her that Mr. Samuel assaulted Mr. Siabi in Limpopo. That's what you're telling us?
That is not what I'm saying. That is not my...
What is it that you're telling us?
I said she might have acquired that knowledge while she was working for the SSA. As to how she got it, whether from someone or she acquired it herself, I don't know. I've just alluded to the fact that if I know I'm going to work for a particular department, or the chances are good following an interview that I'm going to work for that department, I would research enough, or even preparing for the interview, enough for me to be able to demonstrate knowledge of who I'm going to work with, about that institution and so on. So that is the same credit I would give her. It was perfectly within her means to do that.
Yeah. Mr. Samuel. The other thing that revived this incident is that the Public Protector of South Africa was being sued by Mr. Siabi. You're aware of this?
Yes, I'm aware, because I was also being sued in the same case as the second.
Yes, you were the second respondent.
Defendant, yes.
Second defendant, rather, yes. Now, and even in the regional court, you were the second respondent, and the first respondent was Public Protector of South Africa.
Are you referring to a separate action or?
Yes, I'm talking about the regional court matter, which you signed on the 28th of August 2018, which you don't have.
I am a second defendant. I'm a second defendant.
No. I can read.
I'm not. When you say respondent, you might be referring to an application.
Yes, it is an application. Yeah, it is in the matter between Siabi Nchaupe Peter and applicant and Public Protector of South Africa, first respondent, Spello Hamilton Samuel, second respondent. That's what it says.
Yes, the heading might reflect that, but I've never been served with papers to go and respond to any application or any application that might have been brought. I didn't have any. I'm only defending the action where I'm being sued for 350,000 rands. Anything else, I was not served with those documents. So to that extent, I'm not responding.
Nkuna attorneys were your attorneys?
Yes.
Yeah. So, okay, well, they received this. But anyway, that's not the issue. The issue is, you are aware that Mr. Siabi was suing the Office of the Public Protector, the Public Protector. By the way, we'll come to that. That distinction. The Public Protector and you for 350,000 rand, right?
Yes, I'm aware.
Yes. And that revived this matter, at least in the eyes of the public protector. You didn't need the SSA. They were served with papers, correct?
That's correct.
Yeah. Now, once that happened, the public protector was in jeopardy, jointly and severally with you, of paying 350,000 rand, correct?
That's correct.
Yes. And therefore, that high amount of money would be something of interest to the public protector, correct?
That is correct.
And the public protector had the right, therefore, to find out what is this all about. Let's assume she was not a spy.
That is correct. Well, when I say what I was about to say, as she did,
as she did. No, you're right.
Through the relevant managers.
Yes,
notably, yes.
Thank you. So you accept that this had nothing to do with the SSA?
Yes, from that point of view, I accept it.
Thank you. You see, that's the value of cross-examination, Mr. Samuel, because without cross-examination, this committee and the whole nation would be left with the impression that that's how she acquired the knowledge. You understand that?
Yes, I understand it, but as I say, I did not have any information of how she acquired it.
Yes,
and that was why we drew that, I drew that.
Yes, thank you. No. Yes. The whole council knows that now. I'm just saying, when I say cross-examination, it's like jazz. You must listen and sit back and not interrupt it and appreciate it. It's art. Okay. So then, now that we know that there was this issue, do we accept that the fact that that the matter was then revived, as the terminology we have used, may, and I won't put it higher than that, may actually be for a legitimate reason, not because of your intellectual prowess or because of some vendetta against you. I accept that that's what you thought, but do you accept that there may have been a genuine reason to pursue the matter?
Could you please
rephrase? Okay, I'll rephrase.
Rephrase or repeat the question.
Rephrase, rephrase is better so that I don't have to do it word for word. Yeah. I'll shorten it to make it easier. Do you accept that there may have been a legitimate reason for the public protector to revive the matter, culminating in the charges against you?
Yes.
Thank you. All right. Now, you see, Mr. Samuel, now I'm not used to you making...
In the meantime, you're looking at, if I may just qualify my last answer. Yes, there may have been a legitimate reason for her to revive the matter. But that is not what happened.
Yes.
And my belief is that it only happened because I had lodged a complaint against her with the speaker.
Yeah.
That is my evidence.
All right.
Just pause there. Thank you, Mr. Samuel. It's now 3:30. I had indicated in the morning that I will re-examine at 3 the time for Mr. Mpofu. I would want us to take a 15-minute break now. Be back after 15 minutes. And I will extend Mr. Mbofu's time until 5 and push back the members into the morning. Thank you very much. Let's take a break.
Chairperson, for what it's worth, maybe before you even take a break, I'm not going to finish at 5.
You will have to prioritize.
We'll deal with it at that time, yeah. But I'm not going to finish at 5.
I'll end it.
I might not even finish tomorrow.
And we'll start with the members in the morning. The art of jazz.
Honorable Hendricks.
I see you've just left your instrument there.
Honorable Jumat.
People are getting caught. Honorable Maneli.
I've always been here, Chair.
And we can even see you. Okay, thank you, Honorable Maneli. We proceed. Mr. Samuel, you ready?
Yes, I am, Chair.
Thank you very much. I hand over to Advocate Mbofu.
Thank you, Chairperson. Mr. Samuel, apart from the assault story that we have dealt with, which was just one of the charges. I'm sorry, that's confusing. When I talk about the charges now, I'm talking about the disciplinary charges against you. Excuse me, we're not talking about the criminal matter.
All right.
Yeah. The first charge that we were found guilty of was that you displayed an improper and disgraceful and unacceptable behavior towards Mr. Siabi, correct?
It is fair hearing, yes, correct.
And then we'll jump the one of assault. Then the third charge was that you brought the name of the organization into disrepute for obvious reasons. Correct?
That was the third charge, yes.
Yes. The next one was non-compliance with the grievance procedure. That had to do with your so-called initial statement, which you sent to Parliament instead of raising it within the prescripts of the grievance procedure, right?
That is correct, Chair.
Next charge was failure to comply with the PPSA policy. Procedure within the organization dictates that you should have raised that matter internally.
I accept that that's what the grievance procedure says, but I need to qualify that. The grievance procedure is applicable to employees of the PPSA.
Yeah.
And the public protector is not an employee of the organization.
Yes, but you are.
So it's not applicable to her.
No, that's fine. But you are an employee.
Yes, I am.
It's applicable to you.
Yes, it is.
Thank you.
Let me just add, but in relation to my grievance, now that we're using that term, that I could not have raised it with the PP because she was the subject of what I was complaining about. And the fact that it is not applicable to her as she's not an employee of the PPSA.
Yeah, no, I understand. That's very impressive. Okay. So, but by that, surely you don't mean that when employees at the PPSA have a problem with the PP, the only way they can deal with it is to do what you did, which is to write to Parliament.
I cannot answer for other people, but for me, yes, that's what I saw fit, and I still believe I was right. And in fact, in the arbitration, I think you've been asking me now during this session that I was found guilty. I don't know whether you're going to get to the part that eventually in the, in the arbitration, I was found not guilty because that guilty finding in the disciplinary hearing occurred in my absence. I could not cross-examine witnesses. I could not place my version. And so effectively, I could not test that. So because it happened in my absence, they simply took the shortcut and led evidence which was not tested, and that's how I was found guilty. That was all reversed on the arbitration.
No, I didn't say anything about guilt.
No, but you did. You said I was found guilty of on those
you were
charges.
charged. I've said you were charged, Mr. You were found guilty, but I said you were
I'm
charged.
sorry, I don't want to enter into dialogue, but you did, Mr.
Okay, no, let's kill the debate. You were found guilty by Advocate Mahambi of these things, correct?
Correct, yes.
Thank you. All right. So the next one was an alternative to charge 5 misconduct and communication policy. This is when you went around speaking to Radio 702 about the public protector. Is that also because she's not an employee? You think you had the right to go to the radio and disparage her?
I was not found guilty of that, but I was not found guilty on the alternative charges by Advocate Muhambi. But insofar as I went around and spoke to the media, yes, I did. But that was in relation to the affidavit that I sent to the speaker that they wanted to interview me. I was charged for engaging with the media in violation of the communications policy. But my defense then and now is that I was not speaking on behalf of the office. It is only an offense if I was speaking on behalf of the office. The person that was speaking on behalf of the office was Mr. Sahalo, not myself.
All right. So this is how you want to get away from these things, by these technicalities. She's not an employee, and therefore you can bypass the grievance procedure, and you can speak to the radio because you're not speaking on behalf of the company. Really? Do you think an employee should be allowed to go and speak about their employer on national radio or regional radio, whatever this is, based on those technicalities? A senior person like you.
What I was asked about in the interviews was the content of my affidavit.
Yes.
And I confirmed that my interviews related only to confirming that I was the author and that's the contents I drafted and so on.
No. Thank you, Mr.
Advocate Mbofu, Advocate Bauer.
Mr. Chair, we have 2 disciplinary proceedings, a disciplinary proceeding before an advocate, and then we have it overturned at the CCMA where the witness was exonerated and the charges were set aside. I want to raise 6.1 and 6.2 of the directives as to the relevance this has to the motion.
Advocate Mbofu.
Yes, okay, well, the 2 relevances. One is it goes to the credibility of this witness. The second one is that it goes to the extent to which Advocate Mkhwebane has been abused by all and sundry, including this witness, who has now just told us from his last answer that he was going around doing radio interviews to confirm the statement that says Advocate Mkhwebane is intellectually challenged.
Okay.
Thank you.
Let's proceed then.
Thank you. So,
Chair, I just need to correct Advocate Mbofu. I did not go around in those interviews. I was never asked about whether or not Advocate Mkhwebane is intellectually challenged. I was only asked about whether I was the author of that affidavit and the letter, and whether I stand by the contents. But specific questions that were put to me that I responded to never touched on what he suggested.
Fair enough.
Okay.
But you confirmed the contents of the affidavit,
Yes, I did.
and the contents of the affidavit is where you say that she lacks intellectual knowledge.
Correct, yes.
And your explanation for that is that she was your boss, correct?
Yes, I
Despite
would-
her intellectual challenges.
To the extent that she's the head of the institution that employs me, yes.
Yes. Now, I was asking you then at a general level. Do you think that any institution should accept that one of its employees goes around saying about their boss that they lack intellectual know-how and all the things that we've already go through, and that such a person should just get away on some technicality that says, no, I was not speaking on behalf of the. Do you think it makes it better if you are speaking on your own behalf? Speaking on behalf of the. Do you think it makes it? Sorry. It's my phone. Sorry, Chair, it's my phone.
Speaking for myself, and this was also confirmed by the ruling of the commissioner in the CCMA, that any criticism or any dissatisfaction or criticism I level against my boss, in the absence of any insult, is actually exercising my right to express my views.
Yes. Thanks. I'm glad you put it that way.
And that should not be curtailed simply because I'm an employee, and so I must not voice that.
Lose your section 16 of the Constitution, right?
Correct.
No, that's not what I'm asking you. I'm saying, fortunately, you've just answered yourself. You accept that Section 16 of the Constitution, which gives you the right to expression, does not extend to insult.
Yes, I do.
And in your estimation, that statement you made about the status of Advocate Mkhwebane's intellectual knowledge does not amount to an insult.
No, it does not.
Why?
It is an observation I made. It was not meant to, I was not attacking or insulting her. It's just an observation I made
that you're making
from her conduct.
Yeah. Do you know why this chairperson was trying to stop me from referring to intellectual knowledge until I revealed that it was from your statement? It's because his instinct was that I was insulting you.
I think if my recollection serves me well, you were labeling me as a convicted criminal. My recollection is that he was objecting to that. And because I had objected to that, he was just protecting me from you repeatedly saying.
No, that's fine. That's it. As a separate incident. There are many incidents here. But that's fine. But okay, let's not be distracted. I'm saying, so your final answer is that you don't think that statement of yours contains insults?
No, I don't.
All right. Then, I know that insulting the public protector is another crime.
Yes, I do.
You do?
Yes.
You've read Section 9 of the Public Protector Act.
Yes.
It's the same as insulting a judge.
I would like it to be put up there, that specific
Section
section.
9.
Yes.
Okay, it can be put up. Section.
Because I
It's
think
actually section 9 1.
you're reading it restrictively, and
It's
a
more
whole section.
expansive than that. Okay.
Yes.
Yeah. No, section
But
9
if
1.
I may just expand on it.
Hmm.
It says it makes it an offense for anyone to insult the public protector in the course of her investigation.
No, actually,
So you're going to say
connection
again
with,
technical.
connection with, yeah.
In connection with an investigation,
Yes.
yes.
But insofar as it is a crime to insult the public protector, sorry, in connection with an investigation, that crime is treated as if that insult was directed to a judge, correct?
That's correct.
So, never mind. But you were charged again for contempt of the public protector. And then disclosure. Sorry, did someone put up the act? Section 91A. 91A, 91B. Yeah. Okay, go up. Yeah.
Yeah.
So the first, you are talking about the one about in connection with an investigation. You were saying in the course of, but I corrected you. It's in connection with, yeah. In connection with an investigation to do anything which, if the said investigation had been proceedings in a court of law, would have constituted contempt of court. In other words, if she was a judge, it would be contempt of court.
Yes, but the reason why I don't consider myself to have insulted her, and that is what the commissioner also agreed with. It was that my conduct did not fall into that category.
Yes, but
Because there was no investigation. There was no investigation that she was busy with when I made that.
Yeah. Okay, another technicality to escape. So you can insult her if there's no investigation in your estimation.
I did not insult her.
No, but you are emphasizing, you're not saying you did not insult her, you're saying that you insulted her, but not in connection with an investigation.
I did not insult her. As contemplated in that act, in that section, I
Yes.
did not insult her.
Okay, well, you are wrong about that because you were charged, and what you've just said applies to 91B, correct?
That's correct, yes.
But you were charged with offending 91A, correct?
Correct, but I'm looking, if you're reading that section, that whole section. B from A, it is an extension of that.
No, you can't. But let me explain to you, and I don't want to go into, I've debated this in court. I'm saying to you, you were charged under section 91A, yes or no?
Yes, I was.
Yes, okay. Now, it says that, and actually it says here, on 17 February, you intentionally negligently approached or permitted yourself to do an interview on television broadcast, the Radio 702, with the intention of making derogatory and disparaging remarks about the Office of the Public Protector of South Africa, its leadership, and the Public Protector Advocate Busum Kubane, and the manner in which you conducted yourself was solely meant to be contemptuous towards the Public Protector Advocate Busum Kubane, thereby contravening the provisions of Section 91A of the Act referred above. Correct?
That was the charge. But
Yes.
it did not necessarily mean that that was a fact. It was never proven.
No, sir. Working with me here. I'm saying you were charged with 91A.
Yes, I was.
And 91A has got nothing to do with all these escape routes that you're trying to design. It says no person shall insult the public protector or deputy public protector. That's it. Right?
That's what, yes, that's
Yeah.
what A says.
So it's got nothing to do with investigations.
But Mr. Mbofu, I'm not going to pretend to be an expert in legislative drafting, but I do have a certificate in legislative drafting. And
Good for
the
you.
reason why there's that semicolon there, there's a reason why. It's because that's not the end of the sentence. Else there would have been a full stop. It goes on. It means you and I would know. I'm sorry, I can only think of a Latin maxim here. You must read the whole section. It is part of the same thing. Eustem generis.
No.
It's part of the same thing.
Okay, that's
It is
fine.
not.
I will leave that because it's interesting, but it's not directly relevant to this. What you're saying is syntactically incorrect. There's no such English sentence that can say, no person shall insult the public protector or deputy protector in connection with an investigation, do anything, which, what is that? Which, if they said investigate, you can have two verbs, but that's never mind.
The commission agreed with me.
Never mind. No, that's fine, Mr. But at least for the purposes of this committee, you accept that you are charged with 91A,
Yes, I was.
which talks only about insulting the public protector.
Yes, I
So
was.
if you can show that the contents of the statement were insulting to the public protector, you would be guilty under 91A. Maybe.
If that is proven,
Yeah.
I wish I deny that it can
Yes.
be proven.
No, I know you deny it. And then you'd be a convicted criminal again. And it would be under section 11, any person who contravenes.
Mr. Chairperson, sorry, I don't want to interrupt you, but we're now retrying the proceedings before the CCMA and coming to a finding of guilty and saying then you'd be another convicted criminal again. I don't think that's a fair approach to be taking with a witness.
Witness has just answered, Chair, and I don't know what's happening now. The witness just said, yes, if that was shown, he would be guilty.
Okay, just pause. I've got both Honorable
Sorry, Chair.
Milam.
Thank you, Chair. Chair, could I just get a clarity, and I'm not sure who to ask it of, as to whether or not there were criminal charges in terms of section 91A brought against Mr. Samuels?
And ask me.
So I'm just trying to get a clarity, because that would then go to what Advocate Mpofu has just said, that he is then a criminal again. And I'm just trying.
I never said that, Chairperson. I said, I choose my words carefully. I said, you would. Now you're changing it to is. Please, don't put words in my mouth.
Chairperson, that's why I asked for a clarity.
Yeah.
I'd appreciate it if Advocate Mpofu would just hold himself back a little bit and remember that we are a committee of parliament and we are entitled to ask these questions.
Yeah, I'm also entitled to answer them. So,
With respect, Advocate, with respect.
now listen here.
Yes, hold back on the dialogue, Advocate Mpofu.
No, Chairperson,
He's still,
you know,
he's still
okay,
on the floor.
let him finish.
He's still on the floor. Honorable Milam. Please continue.
In terms of section 91A, section 11 of the Act.
Okay. Before I come to you, Advocate Mpofu, Mr. Samuel.
There were no criminal charges laid against me, Chair, in terms of any of those sections.
Chairperson,
I was only charged internally in the internal disciplinary hearing. So there was no-
Chairperson, I'm raising an order.
Yes.
I object to this. The directives are here. You are the chairperson. Chair us.
Which is what I'm doing, Advocate Mpofu.
Yes, the directives say that members may only ask a witness after the cross-examination. So Honorable Milam cannot ask the question to a witness. That's why I was giving him a leeway to say, ask me. And he doesn't want, he asked the witness. He's breaching your rules and we cannot allow it to
I
happen.
hear your
here.
point. The members are not on questions now. It's a point of clarity. And in any of the situation, whether it's done by the evidence leader or yourself, if there's clarity sought, I can't hold back
On
on
the
that.
witness.
Yes, I can do that as a chair. to say what you're saying, is this what you're saying in terms of clarity? So that's not a question that you're asking.
Yeah.
Was it respect that the evidence leader still understand that you still understand?
No,
So that there shouldn't be any train smash on seeking clarity
no, I accept that, Chair.
on any issue.
I accept that from the chair, but I don't know there's a deputy chair.
No, don't go there. Chair.
All right.
There's no deputy chair here.
Okay.
There's one chairperson.
All right. Thank you, Chair. No, that's fine.
Let's proceed.
Let's proceed. Thank you, Mr. Samuel. I accept, just for your own comfort, that you are not criminally charged with Section 91A. Okay, so let's just be clear on that. That's why I use the word would. So I was saying, if you were, I think you and I were moving along correct and nicely. I was saying, if you had been charged of Section 91A, and for a minute assume that, I know there's a debate between you and me about the interpretation of the section, but just indulge me if you accept my version of that. I'm saying that would then make you guilty of an offense under Section 11. I'll just leave it at that.
That would be
No.
the charge, which still needs to be proven. Yes, if it was proven that I'm guilty of it, yes, I would.
Yes, yes. No, you did say that in fairness. Yeah, thank you. Thank you. All right. And the next one was contravention of the Protection of Information Act read with declaration of secrecy. Remember that?
That's correct. Yes.
The other one was inciting fellow employees to participate in an unprocedural act. That's the one about you campaigning or canvassing other employees to join you to ask for the resignation of Advocate Mkhwebane, correct?
That was the charge, but I deny what it says.
Yes. Okay. Which part do you deny? You did call for the resignation of Advocate Mkhwebane.
I did, but in relation to fellow employees, all I said was that they too have information and that if they want to, they can come forward and not complain to me because I had come out and they were talking to me. That is what I meant. No. And I was not, I was not inciting them. I was only saying they can come forward.
You're asking them nicely. Yeah, okay. So let's take it step by step. Let's forget about the other employees. You alone, you called for the resignation of your boss, correct?
Correct, yes.
And so that's the kind of employee that you are. Have you ever heard of such a thing? Of an employee going public to call for the resignation of their boss? What must happen?
I was not instructing her to resign. I was asking her to resign. She could easily refuse.
Yes. Yeah, no, that one. Have you ever heard of such a thing? Asking nicely in public for your boss to resign. What is that?
Yes, I've heard about it.
Where?
I hear it most of the time against politicians. They are always told to resign,
by who?
Even by people that work for them in the department.
Oh, so you are a politician?
No, I'm not.
Okay, apart from politicians, have you ever heard of...
If you take a minister or an MEC who's in charge of, let's say, COGTA, and a manager or any employee in the department asks him to resign.
You've heard of such?
Yes, I have.
Are you being serious?
I'm being serious.
Okay. Let's assume you have heard of such. Apart from politicians, have you ever heard of an employee calling for their boss to resign at a radio station?
I don't quite understand the question. Sorry, the last part.
Okay.
Have I ever heard of an employee asking for their
Yes,
post
no,
to
it's
resign?
the same
Last
question.
part, yes.
I'm so sorry. I'm so sorry. Finish, Mr. Summer.
No, I'm saying, could you just add the last part to
Yes.
that question?
No, it's the same question that you understood when you gave me the example of the politicians.
Yes.
I'm saying now, apart from the politicians, have you heard of a situation where an employee goes to a radio station or a public platform and call for the resignation of their boss?
No, I have not.
You are the first.
I'm not going to say I'm the first.
You are the second.
I may not have heard anyone say that, but that doesn't necessarily mean that I'm the first.
Yes, it doesn't necessarily mean that, but it might mean that. It means nobody has ever done what you did in the history of mankind.
No, I cannot agree.
Well, I accept that it might necessarily, when you say necessarily, you're saying you haven't heard of everything, like all of us. But I'm saying, but then it's possible that it was the first time that it is being done.
It's possible, yes.
I'm sorry, Mr. I was just talking to the Bible Project. What was the answer?
I said it's possible because I may
Yes.
not have heard anyone.
Yes, no, that's fine. Thank you. And so a person who has done the things that you have admitted to here, you would agree that the only sensible, a person like that should not be seen anywhere near our public protector's office, just as a general statement.
No, I don't agree.
You don't agree?
Yes.
Okay. But if the shoe was on the other side, if you were the public protector, as you might aspire to, and someone did that, and then they went to the CCMA and they were exonerated, as you put it, would you take that award to be reviewed by the Labour Court? Or would you just gladly accept such a person back into the ranks?
Firstly, Council, I don't aspire to be the public protector.
Okay,
But
I apologize.
Assuming that you're saying if I were there in that position.
Yes, just assume without any
My-
inspiration.
Yes. If I were in that position, I would not take that personally to his or her opinion.
No. Sorry, maybe you didn't understand my question. I accept that. I'm saying, let's assume that has already happened, as in this case. So it's an example, but it's based on these facts. Yeah. So I'm saying, if the person was dismissed wrongly, as you're saying, and at least in the view of the CCMA commissioner, and then that person was reinstated, I'm saying you are now the employer and you've been insulted by this person on radio and all over and told that you are retarded. Would you, I'm saying if you are the employer, would you challenge that award or would you gladly just leave it at that? Sorry, if I may add, when you're working for an institution as important as the public protector,
I would, out of respect for institutions like the CCMA, the courts, I would allow that person back. That is a decision that was made by an independent institution looking at what I'm accused of, and so I would allow the person back.
Yes, no, that's the legal thing to do. I'm asking you a different question. You can't not allow the person because there's an award. I'm saying within the period that is allowed in the Labor Relations Act, if you are the employer, would you challenge that award as irrational and reviewable, or would you think it was a rational award to return such a person to their post?
I would accept the award as rational and allow the person to come back.
All right. Well, you are a very kind man, Mr. Salman.
Thank you.
It's a pleasure. You know that the public protector, part of her experience was that she was a prosecutor for the Republic.
My knowledge of that part of her life is that she was an aspirant prosecutor, not a prosecutor.
Yes, that's where I'm going. So that's what you call that's another insult, or at least a mistake. If it turned out that she was not an aspirant prosecutor, but an actual prosecutor, would you accept that that is maybe not an insult as such, but a disparaging remark?
I don't think it would be a disparaging remark. If she's not, or if she was not an aspirant prosecutor and she proves that she was actually a prosecutor, I will accept my mistake. But it had nothing to do with insulting her. And I'm saying that I'm saying that she was an aspirant prosecutor because I've worked with her, and my recollection is that that is what she at some point told me she was.
Anyway, I'm telling you now that she was a prosecutor. So are you prepared to apologize to her?
If she was a prosecutor, then yes, I made a mistake, and for that mistake, I will withdraw it. I will apologize and say I am sorry that I called her an aspirant prosecutor when in fact she was a prosecutor. But I'm taking that from you, that she was.
Okay, you know, when an apology comes with but that's fine. We'll take that one. We must take the best we can get. Are you also prepared to apologize to her for insulting her intellectual abilities?
I don't believe I was insulting her when I was saying that. So
Okay.
I don't see any reason why I should apologize.
Okay, that's fine. Let's assume it was not, you're not insulting her. But would you forgive her for finding it as belittling?
Yes, I would.
Yes. Would you be prepared to apologize for belittling her?
Not if that was not my intention. You asking me about how she would have felt or how she felt when I said
Yes.
that. And
No, that's normally how you apologize.
Yes.
I'm sorry.
If she internalized it as belittling her, I would accept that that is how she feels, but not necessarily that I was in the wrong.
Yes. No, let's say
So
you're in
I
the
would
right.
not really apologize.
So fine. Let's say you're not.
I would perhaps say it's unfortunate that she feels that way.
Yes. And now that she feels that way, would you apologize to her? Because she finds it offensive. I accept what you're saying. You may not have intended it to land like that. But if she finds it insulting, belittling, demeaning, would you apologize to her?
Yes, I would, and, because that was not my intention.
Okay, so what are you waiting for? Can you do that now?
Abraham Kweban, I had no intention of belittling or insulting you, and that is not the effect I have of what I said. It was born by my observations, and how you received it is unfortunate. I'll stop there.
Chairperson, if we were not late, I would ask Advocate Mkobane to respond for herself, but she has asked me to respond on her behalf. Is that she accepts the apology?
Continue with your cross-examination, Advocate Mbofu.
Thank you. Well, thank you, Mr. Samuel. You're again a kind person, kinder than the chairperson at least. Yes, okay. Now that's behind us, we'll have fresh beginnings. So they said that she has orchestrated a plan to destroy the public protector, South Africa. Do you still believe that?
Yes, I do.
Okay. Now, orchestra, you know what an orchestra is? We're moving from jazz now. Mr. Mulder is happy. Orchestrated means who did she orchestrate this with? This destruction of public protector South Africa?
I mentioned that against the background that when she came in, there were numerous senior managers and other lower ranking officials who had been with the office for long and either forced them into resigning or removed them from their positions and replaced them with others that she appointed. So accepting your definition of an orchestra, that those are the people that she brought in to continue her plan.
I see.
Yes.
So the other members of the orchestra were the people who were employed to replace those who left.
Correct. Yes.
That's quite a serious accusation that a public protector is a member of a leader of an orchestra whose intention is to destroy the institution. Quite serious stuff.
Yes, it is serious. I did not take it lightly when I made it. I have explained what I'm basing it on. And I'm basing it on what happened before she came and what happened after she came.
Yes. Yeah. No, in this case, you were basing it on the fact that certain colleagues had been disciplined, correct?
Amongst others, yes.
Yes. And amongst those were the likes of Mr. Kekana, the one who was peddling information that did not belong to him.
Amongst those was Mr. Kekana.
Yes.
That's why I will stop. I don't agree. I can't talk to the other part of
okay,
this.
I can. I'm putting it to you that Mr. Kekana was disciplined and he admitted here before the committee that he had used information which was sent to him mistakenly. And sorry, can I just finish the question? Then you can say whatever.
Yes, finish.
Yes.
Yes.
That
I
that
note
he had
you.
been charged with rather, let me paraphrase it like this. There was an email that was sent to him. It was not directed at him. He got the information and then he distributed it to other people intentionally. At least that's his version before this committee. Again, I might just be paraphrasing one of his answers, but that's the gist. You get what I'm saying? Yeah. So sorry, if I put that, but before you answer, it looks like the evidence leader has something to say.
Just switch off your mic. Switch on your mic.
My recollection was Mr. Kakana refused to deal with this aspect because he said it was subject to appeal, and he didn't make the admission that he was peddling information.
Okay, thank you, Advocate Bauer.
Okay.
What you putting on the table is disputed, Advocate Mpofu.
It's disputed by who?
Advocate Bauer.
Okay, well, that's fine. That's fine. We'll play the evidence of Mr. Kekana. That's fine. You can park that question. I'll ask you tomorrow. All right. Okay, but
You'll ask him when you finish. I don't know about tomorrow. So let's not go there.
okay, I'll ask it when we finish. If it's midnight, it might be 1 minute to midnight. Sorry, it might not be tomorrow. Sorry, Mr. Sama. Okay. So that you are saying were being purged, some of them, like Mr. Kekana, were charged with things like the one I've just described, correct?
I'm not familiar with the charges against him.
But, I'm sorry, Mr. Kapson. How can that be? If you are saying people are being purged, surely if you saw an employee, okay, let's not go to assault, stealing a laptop, let's say, or something, and then they get charged, surely you can't say that person is being purged. The converse of that is that if you know that they are being falsely accused of stealing the computer, but the real reason is that they are intellectual giants, then you can say they are being purged. So how can you make the statement that the person is being purged when you don't even know what it is that they were being disciplined for?
The example you're giving me says if I saw someone steal.
Yeah, let's say
in that case, I would be a witness to the theft.
Yeah.
Yes, I would say that person can be disciplined or should be disciplined. But in this case, I was not a witness to Mr. Kekana passing on information. I hear about that I heard about it in his
when he was testifying.
Yes, and I heard about that even at the time. So
okay, well, at least you heard it.
Yeah.
It's like with
I'm not okay. When he was testifying, I did not hear him say that. What I'm saying is that I heard him when he was testifying. Maybe that part I did not hear because I was not sitting there all the time.
All the time, yeah.
Yes. But prior to that, I knew I heard that within the organization.
Okay. Yeah. Now that you know that he was charged with that, do you still believe that he was purged?
If I'm to follow the example of what happened to me, charges can be brought to purge a person. And to that extent, I believe the same happened to him. If you eventually prove that what you're charging him with actually happened, it would justify that dismissal.
Okay, and if he admits it?
That's also another example of, you don't then need to prove he has admitted. Yes, it would also lead to the same result.
Okay, no, I think we're getting somewhere now. So if I'm correct then, and this is still a matter of dispute between myself and Ms. Bao. If I'm correct that Mr. Kekana admitted or did not dispute that he had passed on information which did not belong to him, as a result of which he was disciplined, would you still hold the view that he was purged?
Chair, I prefer, in the light of the fact that
There's a dispute.
yes, I prefer not to comment on that.
All right. Yeah, okay. The word "if" means you're just dodging the question, but that's fine. I'll let you get away with that for now.
No.
We'll do it tomorrow when that's why I use the word "if," Mr. Samuel. You are a lawyer, you know exactly what I'm saying, but that's fine. The point I'm simply making to you is that I'm prepared to concede at least that those people that you list as being purged, to the extent that they were found by independent chairpersons to have committed the offenses, that you might be wrong.
Not if they're challenging that finding of the chairperson.
Yeah, but that's why I'm saying
It's
you
not-
might be
it's
wrong.
not-
because
It's not the end of that, and it's not like they admitted.
Yeah.
I cannot really say that simply because the chairperson found them guilty, so that they were guilty. I would in any event be implicating myself in that, because the chairperson found me guilty, and I deny that I was guilty,
Yeah.
and I was actually eventually exonerated. So if I'm to use the same analogy, I cannot then assume that because they were charged and the chairperson found them guilty, they are in fact guilty. Particularly if they're challenging that.
Yes. Now, Mr. Kakan, you must listen to my questions carefully. I frame them in a particular way for a reason. I never said just because they were charged, they were guilty, which is what you're saying. I accept for your edification that if they are challenging the outcome, there might be two outcomes. Okay, it might be confirmed or it might be reversed. Yeah, so let's work together. Let's now assume if it's reversed, then you are right, correct? But if it's confirmed that they committed those things, then I'm right, correct?
If that is the end of the process,
Yes.
yes, I would accept.
Right. And then those people in respect of whom those charges would have been made correctly so, and they were confirmed up to the Constitutional Court, those people would not have been purged.
Yes, I'll concede that.
Thank you. Now, can we go to your evidence about the cases? And I think we'll start with your favorite, the Friday. Oh, maybe let's wrap this up because it's some issue that Ms. Bao and I have agreed to deal with in a particular way. So let me get it out of the way. Mr. Ndo, remember him?
Yes, I do.
Yes. Mr. Ndo was the person who was assigned the further investigation when you failed to carry it out, correct?
I did not fail to carry that investigation out. Mr. Ndo worked on the report that I sent to him about the Freire investigation. That was not his role was not to reinvestigate or to investigate because I failed. It was to quality assure before he passes it on. That is my understanding.
Yes, no, I didn't say he had to reinvestigate. Everyone had to work on the work he had done. I'm saying it was assigned to him when you failed to deliver on it, or after you failed to deliver on it.
I did not fail to deliver on that.
Okay, that's fine. We'll come to that. But for the purposes of the present question, is that Mr. Ndo was also, on your narrative, was also purged?
Yes, I believe so.
And you know that Mr. Ndo was charged for sexual harassment?
Yes, I know that was a charge laid against him where I defended him.
But yes, well, you didn't really defend him, but
Yes,
he had asked
I
you,
was representing.
you were going to represent him, yes. And why did you not say that to the commission?
It was not for me to say that.
Okay.
I believe they're in talks with him, and so it's him. He's at liberty to disclose that to me.
Okay.
It's not for him.
No, you're right. I'm told he's going to be a witness. Don't worry. We get all sorts of witnesses here. He's going to come. No, you're right. We'll talk to him. But for your purposes, I'm saying that again, I'm going back to the theme that I was exploring with you now. So the only way, just at a logical level, you'll forgive me, I'm also intellectually challenged. But even for me, the only way that you can conclude that Mr. Ndo was being purged is the same as saying he did not sexually harass anybody. That's effect. In other words, if we accept that there was sexual harassment, then he was not being purged, just as a matter of logic.
I do not follow that question.
You don't follow? Okay,
Yes.
I'll break it down. Let's take two scenarios. One is that Mr. Ndo did not sexually harass anybody, but somebody cruel fabricated that against him, okay? And then he was charged, and then he leaves the organization. That's purging. I think you and I will agree. If he was being falsely accused, and yet he was innocent.
When you say charged, I just want us to be, I want to understand
Yes, no problem.
where do we end?
Yes.
Just charged but not found guilty of what is being charged for. Is that, in what sense are we saying this? I just need
both, really. It's both, because just charging is not purging. Purging is when the person leaves the door. I'm saying if he was charged and found guilty of sexual harassment, when in fact he was being falsely fabricated of such, that would amount to purging. That's classical purging. Agreed?
Agreed.
Yes. Now let's turn the coin on the other side. If actually there was a valid case of sexual harassment and he was charged and he was found guilty, that is not purging. Agreed?
Yes, but that was not the case here.
Okay, which part? Were you a
Mr.
witness
Ndo?
to the alleged sexual harassment?
No, I was not. But
Oh.
Mr. Ndo, I've testified that an investigation was conducted by an independent firm of attorneys.
Right.
And
What did they find?
they found that the allegations against him could not be proven. There was also a criminal case opened against him relating to the same incident.
Right.
And the public prosecutor declined to prosecute for lack of information. So to that extent, I think it is unfair to portray that he actually committed this offense when it had not been proven against him. But he's going to speak on his behalf. I'm not. I'm just answering in relation to the, to the proof that is required to prove that he did that. And I'm not going to be the one here saying that he was guilty of that. It was not my duty.
And that's also not what I'm saying. You might be a kind person, but you're not a good listener. I'm saying to you, we worked together nicely when I was saying if he was being fabricated. Okay, I'm still in that world of if. And now I'm saying if, on the other hand, he had committed sexual harassment and he was charged and he was found guilty, then we cannot define that as purging because he would have had his just desserts.
Yes, I agree.
Thank you. Right. So, Mr. Ndo was in charge of the Friede investigation, at least up to the time that it was concluded. First time, before I'm not talking about the re-investigation. Right?
To the extent that he was my line manager, both when I was in Limpopo and in the Free State, yes, he would have been the overall executive manager in charge of that investigation.
Yes, no, and that is the evidence of Mr. Kekana anyway, which was not disputed. According to Mr. Kekana, that investigation was assigned to Mr. Ndo and Mr. Kekana and Mr. Montusitole. And yeah, Mr. Ndicheni. It might be something not to your knowledge. I'm just telling you that's the evidence before this commission.
My understanding of their involvement was not to investigate. It was to quality assure the report that we had sent through as the Free State office. They did not re-investigate.
Yeah, no, okay, that's fine. It's not important for the purposes of this. Mr. Kekana's evidence was that the report was quality assured by Mr. Matlawe at the drafting stage. And then when he wanted Mr. Matlawe to quality assure it at the final stage, Mr. Matlawe was not here. No, that's the CX report here. The Friede report, according to Mr. Kekan, was assigned to him himself and Mr. Montusitole. As I say, you may not have no personal knowledge. I won't hold it against you. I'm just saying that's the evidence before the commission. You don't have any reason to dispute that.
The information I have was that they were assigned to quality assure the report we had submitted.
Okay, it's fine. Then one of you is not telling the truth. That's fine. Doesn't matter. And Mr. Ndo, if my theory is correct, then Mr. Ndo would have been the person basically responsible for the report to head office, to the public protector.
Correct, yes.
All right, that's fine. Let's not waste time on that because Mr. Ndo is going to come here, I believe, to speak for himself. Have you read the Busasa CR17 judgment?
A long time ago when it first came out.
That's the last time you read it. If not, it doesn't record. You
Yes.
say, is that the last time you read it?
Yes, that's the last time I read it.
Okay. So when you on the 7th of July, but 2 or 3 weeks ago, when you took an oath, so help me God, and included extracts from the CR17 Busasa report, you were doing what? Lying under oath?
No, I was not.
Sorry, can you say that louder?
I was not lying.
Under oath.
Yes, I was not lying under oath.
Yes. So you then the parts that refer to sorry, Mr. Summer. You accept that you referred to the CR17 case in your statement.
Yes, I do.
And you refer to paragraphs of where the things you are talking about are to be found.
That's correct, yes.
And you did that on the 7th of July, a couple of weeks ago.
Correct, yes.
And yet, the last time you had read that judgment was a long time ago, as you described it, correct?
That's correct.
So anyone reading this charge, reading your affidavit, which is a word for a statement made under oath, would be forgiven for assuming that you had read the judgment that you were swearing before God about, correct?
That would be a reasonable assumption to come to.
Yes, it would be a reasonable assumption, but that assumption that those people would be making would be false, correct? Or untrue, maybe false is a strong word. It would not be the truth.
I can't say that that would be the case. I have confirmed that I have read the judgment, but not on the 7th, as you want to confine me to. I said I read it before that.
No, I didn't say you read it before. I said you read it a long time ago.
Yes, a long time. That is before.
Oh, I see.
Maybe
you got me there. Yeah, it could be 100 years, still before. Yeah. Ouch. Okay. Now, and when you refer to it in your affidavit, paragraph by paragraph, that person would then be correct to believe that you read it fairly recently, not a long time ago, correct?
I can't confirm that.
Pardon?
I can't confirm that what you say is
okay. Yeah, maybe I must not. I'm talking about me now. When I read the affidavit, I got the impression that you read it recently, because that's the impression that's given in the affidavit. And you've already said that my impression would be reasonable. I'm saying, but then I would be completely wrong, because you didn't read it.
Yes.
And the impression that you wanted to convey is that you read it recently?
No, the I did not want to convey any impression. There was no impression at all. I wanted to draw attention to the remarks made by the judges. Hence, I went only to those paragraphs.
Yes, sir. But I'm saying somebody who has not read the judgment recently, unlike me, would not be able to tell you what is said in which paragraph. You must accept that as a lawyer.
I said that would be reasonable for the person to think that, but not necessarily true, because that's not what happened.
I'm sorry? What did you say?
I said it would be reasonable for a person to think that, but not necessarily true, because that's not what happened here.
Yeah. Now, Mr. Samuel, I'm saying that you falsely, maybe let me put it just crudely, you falsely gave the impression in your affidavit that not only have you read that judgment recently, but you were able to quote specific paragraphs and name those paragraphs. So I'm saying that impression was a false impression. That's all I'm saying. It's not nothing more than that.
I deny that.
It was a true impression.
It was not an impression. I was quoting the paragraphs that made me make reference in my initial affidavit to the reasons why I asked the public protector to resign.
Yes, I know what you're doing, but I'm saying that when you're doing that, you can't, okay, I forgot you're a genius. Was that from memory that you were quoting those paragraphs?
No, it was not.
It was from what? Because you read it a long time ago.
I did not, when I said, and when I was drafting or preparing for that affidavit, for the supplementary affidavit, I did not have access to those cases. I requested the official that was assisting the evidence leader to go and extrapolate those paragraphs, because that's what I had referred to in my initial affidavit.
Pardon?
I'm saying when this, in preparation of this affidavit, I requested the official who was the assistant to the evidence leaders to go to the exact cases and extrapolate the paragraphs that I was referring to when I said to advocate Enquiry must resign, that made reference to the remarks by the judges. And so that is the assistance I got from him.
I see. So those parts of your affidavit were not from you. They were from the evidence leaders.
I had requested them to put, yes, to go and quote them. Yeah, that was my request. So in all fairness, they were from me because that's what I asked them to do.
No, man. Sorry, Mr. Summer. The references, even by paragraph, to parts of the CR17 Busasa judgment could not have been from you because you only read this a long time ago. So they must have come from the evidence leaders or those working for them, correct?
I have considered to that, yes.
Pardon?
I agree.
Thank you. And is that the same for the references to the CX case?
That is correct.
Is that the same for the references to the Friday report case?
That is correct.
Is that the same for the references to the Financial Services Conduct Authority case?
That's correct.
And that's the core of your affidavit, as I said this morning, is your reference to what you call the scathing remarks made in those 4 cases, correct?
That's correct.
So now we know that you are a phantom witness in the sense that what is contained in your statement, as I said earlier, is not from you. It could have been anybody sitting there, Mr. Temba Kumalo. Because all they have to say is this the judgment? Yes. This is the judgment? Yes. And we sit here the whole day, 1 million rand a day, according to one of the members here. To listen to that.
I signed this affidavit and I stand by the contents. How the contents has come about was by my direction that I'm prepared to stand for.
So if the evidence leaders misquoted a paragraph in the CR 17, the SASA judgment, you would still have signed it?
Yes, I would still have signed it.
Yeah. And if they misquoted another paragraph in the CX judgment and so on, you would have still have signed it and say, so help me God, the contents of this affidavit are the truth, correct?
That is correct, because I believed that what they had quoted there was exactly what was in the court cases.
You believe that?
Yes.
Let's pause there. Thank you, Mr. Samuel. Thank you, Advocate Mbofu. We are going to pause there for the day. As I indicated, we'll finish tomorrow morning with yourself, and from lunchtime, we'll finish up with the witness Hassan Ibrahim. So the inquiry session for the day is adjourned. Thank you.
Thanks, sir.
Recording stopped.